Greetings to everyone in attendance, and thank you for joining us today. This is Thomas, Security and Compliance Analyst with EHR 2.0, and I will be your host for today's event, which is focused on HIPAA, how to comply with limited time and resources. And the company we have presenters with us are from Stroudwater Associates, which is a leading national healthcare consulting firm specializing in mission-critical, strategic, operation, and financial solutions for healthcare leaders with a over 32-year track record in a range of settings. And the presenter featured today is Jonathan Pantenburg, who has more than 12 years of experience advising for-profit, non-profit, and governmental entities through complex issues, including cost reduction, acquisitions, contracts, financial analytics, and operations. Before joining Stroudwater, Jonathan served as Chief Financial Officer and Operating Officer at Kahuku Medical Center, a 21-bed nonprofit critical access hospital on the north shore of Oahu, Hawaii, which under his leadership received accreditation from the Joint Commission and saw increased post-audit total margin and operating revenue. And here at EHR 2.0, our mission is to assist healthcare organizations to develop and implement practices to secure IT systems and comply with HIPAA high-tech regulations through education, consulting, and toolkits. So before we begin, please note that this presentation is being provided for informational and evaluation purposes only and is not intended to be construed as legal advice. So please consult your attorneys for any fact-specific questions under federal law and applicable state or local laws that may impose additional obligations on you. Also, the duration of time will be up to 1 hour, allowing for about 10 minutes of Q&A. So if anyone has questions, you can enter them in the chat window on your screen. So until then, I will hand over the presentation to Jonathan.
Thank you very much. So really what I want to do today is talk about HIPAA from a perspective of where most organizations should be looking at it. With a healthcare law that's been in place for 20 years now, what I don't want to do is spend a great deal of time talking about the regulations themselves. What I really want to focus on is those areas that are of increasing importance for organizations to ensure that they can meet compliance, and really setting up different systems and protocols and procedures that will allow organizations to meet compliance on a regular basis. So the 4 different areas we'll be talking about is the overview. And in this section, what we'll do is just briefly highlight some common terms, some different information about what HIPAA really is. Next, what we'll do is we'll work into the HIPAA compliance area. And this, at a high level, we'll discuss the privacy rule, the security rule, and breach notifications. And what I've done is I've picked a couple high-level items to focus on in those areas that organizations will see on a regular basis. What I don't want to do is get stuck into the weeds on a lot of different things that really aren't going to impact you on a day-to-day basis. After that, what we'll do is we'll look at HIPAA violations and enforcement. And in this area, what we'll look at is how OCR is coming out and starting to assess increasing fines and starting to lead towards monetary penalties, which is really starting to impact organizations overall. And in that area, we'll have different examples of different situations that have led to fines and different things we can do as an organization to try and remediate some of that risk and hopefully put ourselves in a better position. And then last, what we'll focus on is steps towards HIPAA compliance. Now, I realize that there's many different people of different sized organizations on this call. So obviously, some companies will have more robust plans, some will have less robust plans. So some of them may be simple to some organizations, but what I want to do is really just lay the foundation of what people should be doing at the bare minimum to be able to maintain HIPAA compliance and to ensure you're moving in the right direction. So first, what we're going to look at is some of the common terms that we're going to see throughout this presentation. Now, these aren't all the terms you're going to hear. We may talk about some other acronyms, but really what I wanted to do is give you guys the basic terms so as you hear them, you'll know what they stand for and what they mean. The first one is PHI. PHI stands for Protected Health Information. Often people confuse this with patient health information or personal health information. Neither of those ones are correct. Really, it's Protected Health Information. Next is NPP, and what that stands for is Notice of Privacy Practices. We'll deal with this a little bit more when we get into the patient rights section and the different requirements that are set up to ensure that patients know about the HIPAA security rule and the privacy rule, how their information may be used. After that, the next acronym, which is actually the basis of this presentation, is HIPAA, which stands for the Health Information Technology for Economic and Clinical Health. I know that's kind of a mouthful. And really what that will be is the overarching theme of the entire presentation that everything is laid onto. Next is HITECH, which stands for Health Information Technology for Economic and Clinical Health Act, filed by OCR, which stands for the Office for Civil Rights. And this will actually cover a little bit more in detail when we get into the violations and enforcement section. OCR plays a critical role in assessing fines, helping with education, and really working through those different areas. And last, which everybody should know, is HHS, which is Health and Human Services. Again, you may hear other acronyms throughout the presentation, but we just wanted to give these as a foundation to move things forward. So next, we're going to look at really what is HIPAA. You know, although HIPAA had many components, HIPAA is primarily known for Title II, which is the administrative simplification. This component was established, it established national standards for healthcare transactions for electronic information, national identifiers for providers, health plans, and employers. It also addressed security and privacy of information. In addition to those areas, the HIPAA Act also made some revisions to health insurance reform, tax-related health provisions, group health plan requirements, and revenue offsets. Really, the only thing we'll be focusing on today is the Title II, which is those administrative simplification items, and then also additional acts which have led to further revisions of HIPAA and either increased regulations or increased areas for compliance. So really the goal of HIPAA was to require the protection and confidential handling of PHI, reduce healthcare fraud and abuse, and really to set industry-wide standards and a foundation for organizations to rely on and to use to ensure that there was consistency and compliance throughout the organization or throughout the industry. What they didn't want is to have some organizations doing these standards, some having these securities, protocols in place, some doing privacy to an extreme. They wanted to lay a basic foundation to ensure that a bare minimum was in place for the protection of health information. So next, why comply with HIPAA? Simply put, it's required. We as healthcare entities have to comply with HIPAA. Failure to comply can lead to pretty substantial fines, penalties, can lead to other additional both civil and criminal penalties for certain circumstances. I would like to hope that everybody would comply with HIPAA because it's the right thing to do. Unfortunately, that's not always the case. With the regulations, there's not just people that understand the regulations, there's financial reasons why some people can't comply. However, none of those are really reasons for why we cannot comply with HIPAA. At the end of the day, we have to comply with the requirements of HIPAA when dealing with patient information and protected health information. So the next area what we're going to look at is HIPAA compliance, and this is going to be a brief, quick overview of the different areas that we're focusing on today. Again, what I really want to do is I want to focus more time on discussing actual violations to HIPAA and potential ways to remediate those as opposed to talking about the law itself. So the three different main areas we'll be talking about is privacy, security, and breach. And each one of those is addressed under the HIPAA Act. So the HIPAA privacy policy, and it impacts confidentiality, it talks about permitted uses, it talks about patient rights, but really the privacy rule establishes a national standard to protect an individual's medical records and other personal health information. This applies to health plans, healthcare clearinghouses, and healthcare providers that conduct healthcare transactions electronically. Really, a major goal of the privacy rule is to assure that that information is properly protected while allowing information to flow back and forth between providers, insurance companies, clearinghouses, and to promote high-quality healthcare. The rule requires appropriate safeguards to really protect the privacy of personal health information, protected health information, the identifiers, and sets limits and conditions on the uses and disclosures that may be made with permission or without patient permission and authorization. The rule also gives patients rights over their health information. They have the right to examine it under certain circumstances. They have the right to obtain copies. If you are on an electronic health record system, they have the right to review it electronically. They can make changes or request changes to their health information. So really it lays the foundation for all those different areas from a privacy rule perspective. Next is the HIPAA security rule. And what this does is it establishes a national standard to protect individuals' electronic protected health information that is either received, created, transmitted, any way that the information can be used. It establishes those standards to make sure that we have the appropriate safeguards in place to protect that information. So the security rule requires appropriate administrative, physical, and technical safeguards to ensure the confidentiality and integrity of information to secure that protected health information. Next is the breach notification rule. And what this does is it talks about if there is a potential breach, what must we do as an organization to ensure that information is protected? How do we need to notify the public, if at all? Who else do we need to notify? And it sets certain limits and requirements when there is a potential breach. A breach is assumed to have occurred when a covered entity or business associate cannot fully determine that a breach may happen. So what happens is that they consider it a breach when you don't have to prove that there is a breach. You just have to prove that there was the potential for a breach, and then you have to do certain things. And this will lead to additional risk assessments and other items that you have to follow in order to meet compliance. Now, I know with the amount of rules and regulations surrounding HIPAA, it would seem like compliance is a near impossible task. Organizations, regardless of size, they can implement different systems, they can put different policies in place. We cannot protect ourselves 100%. There is always going to be some chance of a risk. Really, the goal is to make sure that we do all the steps possible to mitigate that risk and meet the compliance requirements. So one of the keys to compliance is really evaluating the size and expertise of your organization and realizing what components can we do in-house, what components should we work with an outside partner, and really how should we take this to ensure that information is protected. Not all organizations are going to have the size where they can employ an entire HIPAA compliance team. Larger systems may be able to do that. Smaller physician practices, they may need to engage an outside partner, an outside entity. It's really making sure that we have those systems in place to meet the requirements and really using resources available to us as an organization. So next, what we'll do is really just discuss some changes. The biggest change came with the HITECH Act, and what this did is it put additional restrictions and compliance requirements on organizations with regard to business associates, with regard to notification of breach, enforcement, access to health records. And really what it is as a real high-level overview is prior to the HITECH Act, business associates were not directly responsible for ensuring HIPAA compliance. Really what they would do is they would create agreements with the covered entity, and it was up to the covered entity to ensure that that business associate could meet compliance requirements. With the HITECH Act, what that did was it expanded the liability to those business associates, where now business associates themselves can have compliance reviews, whereas in the past, those compliance reviews would only be conducted of the covered entity. So it's really important to assure that we have those systems in place to make sure that our business associates are meeting requirements. And then also from a business associate perspective, we need to also evaluate what is our responsibilities with regard to HIPAA compliance to make sure that we're meeting those requirements. Next is really looking at enforcement. Prior to HITECH Act, compliance with HIPAA was really more voluntary compliance. Really, the federal government said, you know, we're going to hope that everybody complies. Now, this is not to say that there were no fines prior to that. However, they really worked more with entities to ensure that they were meeting compliance for the HIPAA areas. Since the HITECH Act, we've really moved more towards monetary penalties. We'll discuss some of those later, but the monetary penalties have gone in upwards of $5.5 million, depending upon the level of breach, the level of information that was potentially disclosed or used incorrectly. Next is notification of breach. Really, the HITECH Act, it established requirements for authorized uses and disclosures of unsecured PHI. And really what it did is it said, if individuals' information was potentially impacted, there are certain circumstances where we have to notify the media, we have to notify HHS, we have to notify the individuals, and it laid that foundation to say that if there is a breach, no longer can we not notify people. There's a lot of information in people's health records, whether it be social security numbers, dates of births, and what we really want to do is make sure that if that information gets out there, we need to let people know so that they can take appropriate steps to secure their own information. And then last is electronic health record access. So the HITECH Act, what it said is that for systems that have an electronic health record system, a fully implemented health record system, they had to allow the public the ability to access those records. And if there were those technological systems in place, the public should be able to access those systems. And what that did also is now it put additional burdens on healthcare entities to ensure compliance. Anytime you open up a system to external parties, it increases the potential that there may be a breach or unauthorized access to information. So it really put additional burdens and concerns on the organization to say, what potential do we have for risk and what should we be doing? So next, it's really looking at what is PHI, what is protected health information, and really what protected health information is it's anything that's identifiable that relates to an individual's past, present, or future physical or mental health condition, or the provision of health care for that individual. So really, any information could be down to zip code levels, it could be telephone numbers. All of that is considered protected health information. Anything that could lead one individual to know of a certain individual's health outcomes. Sometimes we see different advertising or different market factors, and we think that maybe at a zip code level, it's hard to identify which type of patient may have had a certain situation. However, what happens is that as you get towards more rural communities, and you have a zip code where there's maybe only 5,000 patients or 5,000 individuals living within that community, and one person had a heart procedure or a heart replacement or some other procedure, if we were to advertise that one person in this zip code had this heart procedure, it's easy for us to figure out potentially who that individual may have been. So there's different requirements that are in place to ensure that we are protecting that information. But really, the protected information is anything that deals with the patient's record or information with regard to the patient. Next, what we're going to look at is some patient identifiers. Although this list provides some patient identifiers, whether it be names, medical records, social security numbers, this is by no means an all-encompassing list. There's many other identifiers that can be included: license numbers, license plates, email addresses, fax numbers, pictures of patients, security cards, insurance cards. Really, any unique identifying number for a patient is considered a potential patient identifier. And those are the numbers that we need to look at when we're either using or disclosing information to make sure that we're not giving out excess information. Next, what we're going to look at is uses and disclosures. And under the privacy rule, it really looks at how you can use information and how you can disclose information. And really, HIPAA allows you to use information for treatment, payment, and healthcare operations. Obviously, if we are providing services to a patient, we need to allow providers to share information back and forth. So it doesn't restrict the ability of one physician to speak to a radiologist about certain outcomes. It allows that. Same thing with payment. We need to be able to get paid for the services that we're providing. So if we were to submit a claim to another entity, we need to be able to ensure that they have enough information to be able to process and adjudicate the claim to submit payment back to us. And the last area is healthcare operations. And what this is normal business operations. Obviously, as we move the healthcare industry more towards quality as opposed to a quantity-based market, we need to look at healthcare information to start driving quality outcomes. So we can use information so long as we're using it for certain defined areas. And really what that does is it takes us into our next term, which is minimum necessary. And the minimum necessary threshold really states that what we want to do is we need to use the least amount of information possible to ensure the protection of health information. However, provide at least enough information to allow whoever is using that information to achieve their objective. So if we're discussing certain things if we have a patient that presents in the ER and they have certain things done, we don't need to send the insurance company every single thing in their medical record. We would only send them the things that were specific to that one individual claim. There would be no reason to send unless they were trying to figure out some type of pattern or something that's specific, but there would be no reason to send potentially like a social security number or a place of employment or different things. What we want to do is make sure that we disclose the least amount of information possible to those who need access to the information. And really what we want to do is we want to restrict access based on a need-to-know basis. A lot of times in hospitals or healthcare providers, employees can have access to different EHR systems. It's using the system a lot of times. You have those procedures in place, you have those systems in place to use those to restrict access to individuals that do not need access. A perfect example is if you are on an electronic health record and you have somebody that works in your maintenance department or a housekeeping department, there would really be no reason for that individual to have access to a medical record of an individual. So establishing those different processes and systems so that that individual doesn't even have the ability to access the EHR. It's really restricting access so that people that don't need information cannot get access to that information. Next, what we're going to look at is the patient rights. And really under HIPAA, it granted certain rights to individuals based on their health information. And really, as we discussed the acronym earlier, one of the most important things to worry about with the patient rights is really getting that notice of privacy practices in place. What you really want to do is you want to get that document in place because it outlines certain ways that you're going to use the information, ways you may disclose the information. It outlines certain rights they have with regard to the information. Now, there are events where a patient does not have to sign that document. The patient has the right to refuse signing the document. doesn't mean that they have to receive care to sign the document. What it means is that we just have to make our best efforts to get that document signed and make sure that they understand the certain things that are in place to protect their information and how the information will be used. Next, what we're going to talk about is really the security rule application. And really, organizations can implement multiple technical safeguards to ensure compliance with HIPAA security rule. The following are some different areas. They can implement administrative safeguards. So organizations, you have to have policies and procedures in place. You have to do annual training for employees. These are all things. New hires should be trained on a regular basis. These are all different things that we can do as an organization to ensure that we're meeting HIPAA compliance. Next, you have technical safeguards and physical safeguards. Technical safeguards are really those system-driven policies or procedures or different factors that are driven out by the system to ensure the safety of information. And some of those are automatic screensavers. Some of those are email encryption. So if an employee were to send out a mass email and the system sees that there's potentially PHI, to automatically encrypt that email or have a screensaver that automatically kicks on after 5 or 7 or 10 minutes. And really, it doesn't state that there has to be certain rules that have to be in place. What it says is that we have to make our best efforts to protect the information from a technical standpoint. So, you know, dealing with the prior hospital I was at, some doctors thought that a 5-minute log off was way too fast. Some thought it should be more 10 minutes. And really what it is it's coming to an understanding based on your organization to ensure that those safeguards are in place to not disrupt operations, but to ensure the protection of information and to ensure operations continue going forward. Next is really the physical safeguards, and these are a lot more of your, you would think they're simple things to do. If you have medical records that are still on paper, put them behind a locked file cabinet. Don't leave medical records on a desk that anybody can look at. It's restrict access to your facility or to certain parts of the facility. Restrict access to servers. It's all those physical things that we can do that allow an organization to protect that information from people that should not be in those areas. Next, really quickly, is breach notifications. So if there is a potential breach, there are certain things we have to do at a bare minimum when there's a breach notification. And really what this is it's to assess the likelihood or the potential that there was a breach. So when completing a breach risk assessment, an organization must really look at the following steps. First, they have to evaluate the nature and the extent of the PHI involved. You know, really those identifiers. Was information sent out with social security numbers or dates of birth? They really have to look at those different areas. Next, they have to look at which unauthorized individuals may have gotten access to that information. They have to assess whether the potential of information was actually viewed or whether it was actually acquired. And then last, what they need to do is really look at to what extent has the risk been mitigated? Have they taken certain steps already? Was it a one-time thing? Are there certain audit controls in place? The goal is really to make sure that the risk assessment is thorough and performed in good faith, and really to set up so that when we reach those conclusions, that if somebody else were to come in and try to repeat our work, that they feel like we approached it from a reasonable perspective and really we tried to assess whether or not a breach really occurred. The next area before we move on to the next section and really get into some of those different violations and complaints is really looking at business associate agreements. And of all the different areas, I would say that this is probably one where organizations overlook the most. It's probably one of the simplest ones to have in place, and really it can lead to a lot of problems down the road. So really a business associate is any person that's not either a member or an employee of the organization that could potentially have access to protected health information. And what a business associate agreement is it really defines those requirements that the business associate must follow to meet the compliance requirements with regard to the covered entity and how they can disclose information and how they must destroy the information. And so it requires subcontractors to meet HIPAA compliance. It states that they have to ensure that there are safeguards in place to protect the information. It authorizes the termination of the contract. And really what it does is it says, in order for us to send you information, you have to comply with these certain things. And really, one thing to note is before you are to send any type of PHI to another entity, a business associate, get that business associate agreement in place. It's something that can be done at the time you execute the contract. There's really, even if you don't think the associate may get PHI, there's really no reason not to have a business associate agreement in place. All it's doing is protecting you as the covered entity to ensure that that business associate does have the information protected in the event that they do receive some of the information. So next, what we're going to look at is really violations and enforcement. So first, what we'll kind of talk about is really the different areas of compliance, the process if a complaint is ever filed against an organization, and really looking at those different factors. Then, as I mentioned earlier, what we'll do is we'll discuss some very current and important factors that companies and entities have been fined for in recent times, and kind of just discuss some steps that we could take to mitigate some of that risk and potentially prevent that from our organization. So OCR, which we discussed earlier, Office for Civil Rights, is really responsible for enforcing HIPAA privacy and security rules. They investigate complaints, they do conduct compliance reviews, and they also really work on performing education and outreach. Their sole job is not to just catch healthcare entities for breaching or breaking HIPAA compliance. It's really to increase awareness and also move the industry more towards complying with the HIPAA requirements and protecting health information. So the first one that they really do is voluntary compliance. And this is really the direction they went initially. Unfortunately, when the updated rules came out, the final rules in March of 2013, they really moved away from voluntary compliance framework and more towards a penalty-based system. And really this was done to increase attention entities give towards meeting HIPAA compliance. And I would like to say that, you know, just really trying to comply with the different requirements should be enough. Unfortunately, a lot of times, because there's so much going on in the healthcare industry with regard to regulations and patient safety and all these different factors, unfortunately, sometimes fines are the only way to get people to take the necessary steps to improve their performance with regard to compliance. The next is corrective action plan, and what this does is it defines certain measures and strict timelines an organization will have to undertake following a breach or complaint investigation, and kind of defines what they have to do. A corrective action can also include a monetary penalty. And then last is a resolution agreement. And what a resolution agreement is it's an agreement between OCR and the healthcare entity, which really it kind of defines what things were done and how they need to take certain actions to comply with HIPAA. It's almost like a brief from a legal trial or a certain thing. Now, one thing that's important to note with the resolution agreement is most of the times, I think pretty much all the times, is OCR's responsibility is not to find true fault with the healthcare entity. If you read most of the resolution agreements, a lot of time there's a disclaimer in there saying that the healthcare entity is not acknowledging guilt or agreeing to the finding. What they're doing is that they're acknowledging that there was the potential for certain things, and then they're stating that they'll pay either some fine or some condition to meet, to settle the claim. Next, what we'll look at is they have a certain process for the HIPAA violations, and I don't want to spend a lot of time on this, but really what happens is when a complaint comes in, OCR will end up reviewing that complaint. There's two different ways it can go, and they can actually run at the same time. If it's potential for a criminal violation, they'll send that on to the Department of Justice. who will then assess whether or not there was an actual criminal intent or some type of criminal action taken, which they would then process. Then what OCR does is they really look at it and they determine whether or not the violation does violate the HIPAA compliance requirements. And if there was a potential security rule violation, they'll investigate, which could lead to a resolution. One of the resolutions we just discussed a moment ago, which is really voluntary compliance, corrective action, fines, formal finding of a violation in those different areas. The monetary penalties, so this is one thing that was changed in the HITECH Act, and really what it does is it increased the potential for penalties for organizations. So there is the potential, even if you did not know or there was reasonable cause or willful neglect, there is the potential for anywhere from $100 to $50,000 fine minimum penalty for certain situations. Fines can go all the way up to $1.5 million per year. And there are criminal penalties, which are also the potential. And really what OCR does is when they're assessing the different penalties when looking at an organization, they're looking at it from the perspective of, is there potential for recurrence? How big is the organization? The goal is not to assess a fine that's going to bankrupt the entity. Really, the goal is to assess a fine that gets the attention of the entity to try to cause that entity to make changes going forward. And that's really the big thing that they're looking at. So next, what we're going to look at is really some common HIPAA violations. And what these are is OCR, they publish anytime there's a resolution agreement, you can go to their website, you can look at exactly the different things that people are getting fined for. But really what I wanted to do is in the course of everyday business, I wanted to point out some type of different HIPAA violations that entities may encounter. First one, really common, lost or stolen device. So a perfect example of that is you have an unencrypted laptop and maybe you're traveling and you leave it at the airport, or you have a certain part of your hospital that's accessible to the public and somebody left a laptop on a desk and somebody were to steal that laptop. This happens quite often. In fact, in 2015, an entity had to pay $850,000 to settle a potential violation. And what happened is that in this situation, the laptop was stolen. There was no proof that the information was actually leaked. The only thing that they showed was that an unencrypted laptop was stolen. And that was enough for OCR to come in and say there was the potential for the leak and there are not certain processes in place. So really what organizations can do to prevent this type of situation is anytime you have a laptop that has PHI on it, make sure it's encrypted. Do certain things like two-step authentication. And what that is that a person has to log in to the system, and then the system will send them a secondary code that they will then have to use that code to do a secondary login. A lot of times people will see this, with banking websites. You go and log into a bank and it says, sorry, we don't notice the computer you're using. Please verify, and it'll send you a text. That's a form of two-step authentication. That's something that people can do. Another thing that systems can do a lot of times is, if you have a laptop, don't store PHI on the laptop. Store it on a server that is protected. And so what happens is that laptop then just accesses a secured location or secured site. So if somebody were to steal a laptop, they're not getting actual information on a hard drive. All they're getting is a device that could potentially access the other PHI, and it's easier to restrict information that way than it is to try to, encrypt it on a laptop or do certain things. Next is hacking. I know there's been lots of things in the news over the past couple of years. People downloaded certain malware. 2016, an entity had to pay to settle a potential violation where an employee ended up downloading some malware onto their computer. And again, in this situation, there was nothing to state that a breach actually occurred. Once again, it just came down to there was a potential breach. There was the possibility that health information could have been leaked or disclosed without permission. And in this situation, there's certain safeguards we can do. Most organizations will have computers that will be driven by system procedures. So establish system processes that don't allow employees on desktop computers to download certain files. Put in virus protection or virus software. Make sure all those things are updated on a regular basis. And just have those certain things in place so that you can ensure compliance. Next, this is actually one of the larger ones that we ended up seeing. So unauthorized employee access, and we kind of discussed this a little bit earlier. You know, if employees have access to health records, you know, making sure that they are only accessing the records that they need to actually access. Recently, in this year, a company ended up getting fined $5.5 million because it showed that some employees had accessed patient names, dates of birth, and social security numbers. And the way that you can end up solving this isn't to say that you're going to stop employees from accessing information. If employees need to be in the EHR, they're going to need to be in the EHR. Billing clerks are going to have to be able to access certain information to process claims. Nurses are going to need to be on records to be able to access health information. What this is it's putting certain audit controls in place so that if employees are accessing things they shouldn't be, you have records that you can then catch it on a quicker basis instead of allowing an employee to go unchecked and really do whatever they want. So put those systems in place, really monitor, have those records reviewed on a regular basis to make sure that the information is protected. Next is improper disposal. And in 2010, you know, a company got fined $1 million for failure to dispose of PHI. Information is stored in a lot of different places that we don't know of these days or we wouldn't even think of. A perfect example is something like a copy machine. You know, a copy machine, a lot of older copy machines have hard drives in there, and we may scan in medical records. A lot of those copy machines will keep copies of those files, and then we end up getting rid of a copy machine, and now it has all this information on there. So really what it is the way that we could protect information is put policies and procedures in place that specifically discuss the disposal. Don't store information in areas that really don't need to be stored. So in the event of a copy machine, ask them to remove the hard drive. Don't store the things. If you end up having one that does have a hard drive, remove the hard drive before you give the copy machine back. If you're going to dispose of a laptop, pull out the hard drive from the laptop, give it to your IT guy, and have him destroy it. It's really just taking those steps to make sure that you're meeting compliance requirements. Next is third-party disclosures, and this one we ended up discussing with business associate agreements. An entity had to pay, you know, $750,000 for sending PHI to a business associate without having an agreement in place. Now, this is not to say that the business associate shouldn't have had access to the PHI. This was just saying that they got access to the information without the BAA. So really, it's taking steps. Get that business associate agreement in place so in the event you do send them information, they sign the document, it's in place. And really, this is a simple fix. It's anytime you're going to enter into a contract with a vendor that may even remotely come into PHI, even if you're going to send it to them on accident. Now, granted, you'll have to follow the breach if you do an unauthorized disclosure or improper disclosure, but at least when you're sending them information to a business associate, they understand their requirements with regard to HIPAA. Next is unauthorized release, and we see this often all the time. I know California has very strict rules with regard to unauthorized release. So in this situation, you know, an organization may send lab results to the wrong fax number, or you may end up calling the wrong phone number and discussing an appointment, or any different type of thing. I remember reading where a company had published all of the future appointments of patients on their website that was accessible. So for this, it's really making sure that when you're sending information, before you just send a fax, double check to make sure that you have the right number. Send information encrypted, so if it does potentially go to the wrong place, you know, where the key will be sent a different way. There's a lot of different processes that we can do that aren't going to cost a substantial amount of money to put things in place. A lot of times it's just slowing down and making sure we're doing things correctly to protect health information. So the last two, and then we'll really move into some of the steps that we can take towards HIPAA compliance, is risk assessments. And risk assessments is a really big one. You know, we should really be getting a risk assessment done on an annual basis. In 2015, an entity had to come in and pay $750,000 to settle a claim from OCR where they weren't getting a risk assessment done on a regular basis. And this isn't to say that that organization wasn't compliant. They could have been 100% compliant with HIPAA. However, without having a risk assessment, they couldn't prove any of the compliance. And that's really, if you notice what a lot of these underlying themes are, is it's being able to prove that you were compliant with the information and that you were protecting the information. And last is unsecured records. And this one is if you have medical records, paper charts, making sure they're in a locked cabinet, laptops, making sure that they automatically log off. If you're in an EHR system, make sure you automatically log off so people can't get access to that information. You know, an entity had to pay about $800,000 for the failure to secure medical records. And in this situation, what ended up happening is they were transferring medical records from one location to another, and they ended up leaving the medical records unattended at that other location, which could have given access to other people. And a lot of this really comes back to protecting the information. So next is really looking at some of the steps we can take towards HIPAA compliance. Now I know, again, some organizations may have a robust plan and may be doing all 6 of these different items. Some may be doing none of these items. And really what it is to say that it doesn't matter where you are on these different 6 steps. HIPAA compliance is an ongoing process. You have to continue doing it every single year. It's not a one and done. You have to continue trainings. You have to continue risk assessments. You have to keep moving forward. So the first one we'll talk about is really forming a HIPAA compliance committee and designating a security officer, conducting a risk assessment, implementing policies and procedures and mitigating risk, train staff and validate systems, conduct an annual risk assessment. So again, on a regular basis, you need to constantly keep assessing risk relative to your organization. And then last, which again will be done on a regular basis, is update those systems and really mitigate risk. So the first one that we'll talk about is really what we'll call step 1, and that's really to form a HIPAA compliance committee. And just to be upfront, HIPAA compliance, there's a large number of requirements and regulations. This really isn't something that could just be passed off to one individual. It's going to take a large number of people, potentially internally and externally, to meet compliance requirements. And really, it's not something we can overlook. It's something we should be done on a regular basis, and the compliance committee should meet on a regular basis. Next is really designate a security officer. And really the security officer is ultimately the person responsible for ensuring compliance at that organization. And really they devise policies, they update policies, they ensure the compliance committee meets, they should be reviewing security laws. And even if you are of a large organization that has a dedicated security officer, again, this is still going to take multiple people. You may have one person that's responsible, but the amount of information is to the point that it's going to take different people to be able to get all these things with regard to compliance. Next, for organizations that haven't done this, it's really conducting a thorough risk assessment. And really what we want to look at is, what is the current state of the organization? What are potentials for risk? You know, do we have a disaster recovery plan? Do we have single points of failure in the system that could prevent us providing healthcare to patients? Do we have, what are we doing with regard to data collection? Do we have policies and procedures in place? What are our audit protocols? And each year that we progress, they're coming out with more and more requirements to maintain HIPAA compliance. You can actually go on or do a search for the different compliance requirements. And a couple of years ago, there were maybe 50 different items. That's not an exact number, I'm just throwing out for reference purposes, but there were maybe 50 different items that they were looking at from a compliance perspective. And now if you were to go and pull down that same Excel spreadsheet, there's probably in excess of 200 different things. And what they're doing is they're starting to get a lot more defined in the different areas they're looking at. Next is, making sure you have policies and procedures in place and really looking to mitigate risk. You have to review your policies. I recommend, update your policies at a minimum on an annual basis. It's not just do something once and then it's done forever. You got to constantly. Technology is changing constantly. We need to constantly update our policies. And once you get that risk assessment, really look at things that we can do to mitigate risk. What are the things? If the risk assessment said there's 20 problems that you have potentials for either breaches or concerns, work to mitigate those things. Next is train staff and validate systems. And really, when staff come in that are going to deal with PHI, train them on a regular basis. It should be part of the new hire packet or new hire procedures that when a new employee comes in, they should be trained on PHI. And then forward, give them an annual training. Regularly update them on how they comply with HIPAA. There's so many different things that there's no way you can cover everything in a single training once a year. But still, at least you're increasing the overall knowledge of your workforce to try to comply with HIPAA. And next, it's really, validate systems. Make sure that your patches are all in place. Make sure that we're regularly updating the systems. Make sure that, email addresses or certain things that we're faxing information to, that those are still current. Then again, I know we discussed this a couple steps ago, but really conduct an annual risk assessment. Do that on a regular basis. It's not something that can just be done once. Every year there may be certain things that are found. Same thing with audits. An auditor is going to come in from a financial perspective and they may not see something in 1 year that they may find the next year. Don't just assume because you got a single clean HIPAA assessment, risk assessment, that you're good forever. With all the changes, different employees and staff, things are going to change. It's something you should be getting done on a regular basis to assess the risk of your organization. And really, again, so after you get those annual assessments, update your systems. Have your systems automatically drive security updates or patches to Windows or email updates, virus protections. Constantly update those different things. And also, as there's legislative changes or administrative rules, whether it comes out from HHS or different guidelines, make sure that whatever we're doing in our system meet those different regulations. And it's also important to ensure that our employees follow those policies. Our policies can't do X, Y, and Z, and then our employees do 1, 2, and 3. The employees should operate based on what the policies state. And again, continue to mitigate that risk. And really, just some conclusions before we move into the questions is really following, it's not an option. If we have protected health information, it's something we have to follow. We may be able to skate by without maintaining compliance or meeting compliance requirements. Eventually, it's a risk where we may get caught. A patient may file a complaint. OCR may come in and do a random compliance review. It's really just making sure that we meet compliance requirements. And just kind of ending, not knowing the requirements is not an excuse for not following. You can't say same thing. I mean, if you're speeding on the road, I didn't know we're supposed to drive, 30 miles an hour and we're doing 80. It doesn't work that way. We as a healthcare entity, we have an obligation to meet compliance requirements and to meet those requirements to protect information. So again, that's the presentation, and thank you. And I guess we'll open it up to see if some people have some questions.
Oh, yes, and we're down to just the last few minutes here, so we try and keep this limited to within the hour. If there are a few good questions, if we don't get to any of them, you're welcome to contact either EHR 2.0 or Stroudwater to follow up on anything that you have about that. Also, as far as getting a copy of the slides, or also asking about if a recording of this will be available, we will plan to have a recording up on accessible from our events page. That's ehr20.com/events within the next few days, hopefully, where we are in the process of making available some of our archives as well of previously recorded sessions, and also this, including this one, I mean. So really quickly, one that I would like to get to is asking for if there is any advice on ways to determine how often should a practice update a business associate agreement with their BA. So maybe another way of looking at this, why is it not a good idea to just have a contract signed that is in effect for 10 years or more, or even indefinite amount of time?
Yeah, so what I wouldn't do is, because legislation could change things at any given time, and what the BAA should do is it should correspond to the contract that you're actually executing. So if you have a contract that's only good for a year, I wouldn't set a BAA that's in perpetuity. What I would do is set it at a year. It's not much hassle to get an additional document signed. If you're doing an amendment to a contract, there's not any reason why you can't also amend or update the BAA. And really what it is it's just to ensure that if there are changes to your BAA, that those get implemented with the providers. And what I would definitely do is, if you were to make major changes to your BAA to incorporate certain administrative changes, I would send those out and get those updated or re-signed with entities. It's not to say that you have to immediately, but what you don't want is you don't want practice or policy to differ from what your BAA is stating from an outdated perspective.
And it looks like we just have a follow-up about that. So what about if there is no contract? Is this then, would they say, they're asking still do it annually, but let's say they have a BA they're working with, but there is no contract in place. What should their immediate steps be? Or can they still operate with them or work with them, or should they cut off all, not contacts, but any work with them would be postponed until they get a contract in?
Well, I mean, from a perspective, you should have the BAA in place. Technically, there's nothing, you can send health information to any single person in the world, and that's part of the problem, is that the BAA it outlines the requirements of that business associate agreement. So you may not have a specific contract with somebody in place, whether it be a monetary contract or professional services agreement or whatever. But really what you want to do is just to ensure that you have a document in place in the event that that person does receive PHI.
Right, I look at it the way is that it's for your own sake. You want them, a big part of the contract is they're accepting responsibility. If something is breached on their end, then without the contract, you're the one who is accepting all liability.
Exactly.
And Jonathan, unfortunately, this looks like we are running at the last minute of time here. So as I mentioned, unfortunately there were some good questions we did not get to. If you wanted to go to the slide where they can see some of your contact information, or also for our site is EHR 2.0. The email would be info@ehr20.com. You could also run those by us as well. But otherwise, Jonathan, we do appreciate this overview on how to comply with limited time and resources, and for taking a few minutes of time for our questions. So as a reminder, you can sign up for our mailing list, if not already, for news about upcoming events, including, we have an upcoming session next scheduled is September 20th at 1 p.m. for HIPAA compliance requirements for law firms. I believe that one was rescheduled from before when we had some internet outage with our presenters previously. So thanks again to everyone who attended, and for Stroudwater, including Jonathan Pantenburg and his assistant, who has been working behind the scenes to help get this organized. So that was Kimberly McCall, who's been very helpful as well. So thanks again, and we look forward to working with you all again soon.
Thank you very much.
Thank you.